Subscribe to our YouTube channel and press the bell icon so that you never miss any video lesson from RAU'S IAS Study Circle. Hello and welcome to the Daily News Simplified, an analysis of the Hindu newspaper from UPSC perspective. Today we will discuss the Delhi edition of the Hindu newspaper dated 7th November 2022. And the articles that we will discuss today are displayed on your screen. So let us start the discussion. This article on page number 8 is related to one of the important debates about implementing one of the most important DPSPs in the Indian Constitution, and that is related to Uniform Civil Code. Now, this provision under Article 44 has generated much debate about its implementation across India. However, even after 75 years of independence, the Uniform Civil Code still remains to be implemented and the law still remains to be enacted related to the Uniform Civil Code in India. Now, in this backdrop, various political parties are demanding the implementation of Uniform Civil Code in some of the states, as well as there are demands of implementing the Uniform Civil Code at the national level. And that is why it is important for us to understand the whole debate surrounding the issue of Uniform Civil Code and its implementation at an all India level. So in this discussion, we'll try to understand the various debates that existed even during the Constituent Assembly debates, plus what are the constitutional provisions, what are the arguments in favor, and what are the arguments against the implementation of Uniform Civil Code. But first, let us try and understand what exactly is this Uniform Civil Code. So if you try to understand the Uniform Civil Code, in the Directive Principles of State Policy under Article 44, it states that the state shall endeavour to secure for citizens a uniform civil code throughout the territory of India. Now, if you try to understand the personal laws or civil laws in India, which regulate the issues related to, let's say, marriage, divorce, inheritance, adoption and maintenance of different religions, they are presently governed by the laws relating to different communities. For example, there are laws related to Muslim personal law, there is law related to Hindu personal law, and all these laws exist differently. And that is why there is a demand for bringing about a uniformity in these laws, bringing them under one common law, which will be called as the Uniform Civil Code. So that is why UCC is the proposal to administer same set of secular civil laws to govern all people irrespective of their religion, gender, domicile, caste, etc. So once this Uniform Civil Code or civil law is implemented, it would replace all the distinct personal laws of each religion which are relating to marriage, divorce, adoption, inheritance, etc. And this Uniform Civil Law or Uniform Civil Code will then govern issues associated with marriage, divorce, inheritance, etc. commonly through only one law, which is not the present case because presently these issues are being dealt with differently. Because the concepts of marriage, inheritance, etc. are different in different communities in India. And that is why it is difficult to arrive at one common law governing all these personal issues. However, since Article 44 under the Directive Principle of State Policy provides that it should be the duty of the state or state shall endeavour to create a common uniform civil code, and that is why it has generated much debate that the UCC or the Uniform Civil Code should be implemented across India. In this line, let us try and understand the debates that existed during the Constituent Assembly debates. So the first debate that was there in the Constituent Assembly was that should uniform civil law be included as a fundamental right or as a directive principle. In this line, Dr. B.R. Ambedkar proposed that the UCC should be included in the directive principles of the state policy. And this Article 44 of the Directive Principle of the State Policy, which proposed that the state shall endeavour to secure a UCC, which means it would not impose it on all the citizens and it should be purely voluntary, and slowly and steadily and gradually this transition towards the Uniform Civil Code should be done. So finally, it was decided that securing a uniform civil code was not within the scope of the fundamental rights and it should be included in the DPSP. In this line, one of the Constituent Assembly members, Nasiruddin Ahmed from Bengal, although he was not against the implementation of the Uniform Civil Code, he argued that certain civil laws in India in all the communities were inseparably connected to religious beliefs and practices. For example, the way in which the marriage is considered is different in case of different communities. Also, the laws governing or the issues governing inheritance are different in different communities. And that is why he felt that civil laws in all communities are inseparably connected with religious beliefs and practices. And that is why he felt that the UCC would come in the way of right to religion under the fundamental right. So while he was not against the idea of a uniform civil law, but he argued that it was not the right time for the UCC and its implementation, and the implementation of the UCC should be gradual in nature and not without the consent of the concerned communities. So that was his whole argument. Further, K.M. Munshi in the Constituent Assembly debates highlighted that the UCC was not against the freedom of religion because Constitution had allowed the government to make laws covering secular activities related to the religious practices if they were intended for social reform. And that is why he was in favor of implementation of the Uniform Civil Code, because he felt that it was important in promoting the unity of the nation, equality for the women, and it will also help in removing various discriminatory practices of the Hindu personal law. Now we are aware that even though the personal laws or the civil laws are governed by different laws related to different communities, however, we see instances of gender discrimination in various issues associated with civil laws. For example, in case of marriage related laws for different communities, there is kind of discrimination against women, and that is why there were calls for uniform civil code. However, there was no consensus how it should be implemented, and that is why it was left for the governments of the day to implement it later through a law, and it was not implemented by the constitution itself, and hence it was included in the Article 44 as a directive principle of the state policy, where the state should endeavor to secure the uniform civil code in the future when the time is right for this thing. So if you look at the Indian constitution, the UCC has been provided as the directive principle of state policy under part 4, and it says that the state shall endeavor to secure for its citizen a uniform civil code throughout the territory of India. The objective of this UCC was to harmonize diverse cultural practices and address the discrimination meted out to various vulnerable groups under the garb of the religious practices. So this is the whole idea or intention behind UCC and why it was incorporated as a directive principle of state policy. Now if you look at the benefits that would arise from the Uniform Civil Code, and if we are aware that the Uniform Civil Code governs the personal laws which are based on religious beliefs and practices, we find that certain religious beliefs and practices are discriminatory in nature. So that is why a UCC would try to do away with such kind of discriminations. So the first benefit is that the UCC would not only protect the vulnerable sections, including women as well as religious minorities, but it would promote nationalistic fervor through unity as well as simplify the complex personal laws. Further, it will do away with diversity in the matrimonial laws. It will simplify the Indian legal system and will make Indian society more homogeneous in nature. Also, it will link law from the religion. Presently, these laws are certainly inspired from the religious beliefs and practices. Further, it will create national unity and will help in containing the vociferous tendencies in the country. Also, it will help in establishing social justice as well as gender equality in the family matters, especially in case of marriage and inheritance. Also, the introduction of UCC will promote monogamy among all the citizens of India, including the Muslims, and it will lead to betterment in the position of the women. Further, it will also remove prejudices against women regarding personal laws on divorce, maintenance, etc. And it will help in strengthening the secular fabric of the country and promote unity. So all these are the benefits that will accrue if a uniform civil code is implemented, because it will try to reduce the discrimination against various vulnerable sections, especially women in this regard. So in this line, what has been the stand of the Supreme Court in its various judgments related to the Uniform Civil Code? So in the famous Shah Bano case in 1985, the Supreme Court had ruled in favor of Shah Bano, who had moved to the Supreme Court seeking maintenance under section 125 of the Code of Criminal Procedure after her husband had divorced her. And in this line, the then Chief Justice of India observed that a common civil code would help the cause of nation integration by removing disparate loyalties to the law. And the court had directed the parliament to frame a uniform civil code. However, the government of the day was not ready to implement the Uniform Civil Code, and despite this judgment, the government in 1986 enacted the Muslim Women Protection of Rights on Divorce Act, which nullified the Shah Bano judgment, and the act allowed maintenance to the women only for 90 days after the divorce, which was inspired by the religious beliefs of that time. In another major judgment, that is the John Vallamatham versus Union of India case in 2003, the Chief Justice of India had observed that it's a matter of regret that the Article 44 of the Constitution has not been given effect to, and the Parliament is still to step in for framing a civil code in the country. In the S.R. Bommai case, the Supreme Court had warned against mixing politics with religion. That is, the Supreme Court had warned that a uniform civil code should not be implemented in such a manner which will be discriminatory in nature against various religious communities. Because the SR Bommai case had highlighted secularism as one of the important basic structure of the Indian constitution. In this line, the court had worried whether a secular state should bring a code which can be perceived to be a threat to the personal laws based on the religious beliefs of individual religions. In this line, the Supreme Court has also called on the government to implement the UCC in the 1995 Sarla Mudgal judgment as well as Paulo Coutinho versus Maria Luisa Valencia Pereira case 2019. So in all these judgments, Supreme Court has highlighted that the UCC should be implemented except for the SR Bommai judgment. In this line, the next important thing for us to understand is the observations of the Law Commission in its report in 2018. In this, the Law Commission observed that the Uniform Civil Code was neither necessary nor desirable. And that is, the UCC is currently neither necessary or nor desirable in India. So rather than implementing a Uniform Civil Code, the Law Commission had provided certain suggestions that could be made in the personal laws presently. So the Law Commission had recommended that there is a need for religion-wise amendments. And the Commission had recommended religion-wise amendments in personal laws to end discrimination against women within the communities. So that would be a better option to do. That is, do away with the discrimination that exists in the personal laws. That is why diversity would be accommodated and laws would not be discriminatory in nature. So in this line, the Law Commission had recommended ensuring equality within the community. So in this line, the Law Commission had recommended the Parliament that it should first consider equality within the communities, that is between men and women of the same community, rather than equality between different communities. And in this way, some of the differences within the personal laws which are meaningful can be preserved and inequality can be weeded out to the greatest extent possible without absolute uniformity. And that way, the diversity would be accommodated very easily. So the Commission had recommended to preserve the diversity of the personal laws in the absence of consensus through codification. So it recommended that it is desirable that all the personal laws relating to the matters of the family must first be codified to the greatest extent possible, and then the inequalities that have crept into the codified law should be remedied by the amendment. So this brings us to what are the arguments against the Uniform Civil Code. First is that the UCC would be against the right to freedom of religion because it will introduce state interference in the religious affairs, and hence it would be against the concept of secularism and may even violate Article 25 of the Indian Constitution. Further, it may impact the cultural practices of some of the tribal communities in India. Also, considering the plural nature of the Indian society, it would be a complex task to unify all the personal laws of all religions, caste communities, tribes, etc. across the country regarding marriage, divorce, adoption and succession. Also, amendments can be made by the states. So it is said that even though India has uniformity in most criminal and civil matters like Criminal Procedure Code as well as Civil Procedure Code, yet different state governments have made several amendments to the CRPC, IPC and different civil laws to meet the local conditions. And finally, it is argued that the personal laws have been put under the concurrent list with this kind of consideration. So the constitutional law experts argued that perhaps the framers did not intend total uniformity, which is why personal laws were replaced in entry 5 of the concurrent list, thereby providing legislative incompetence to both center and the states. So these are some of the arguments that are forwarded against the implementation of Uniform Civil Code in India because it is seen as against the right to freedom of religion. It may impact the cultural practices of some of the tribal communities, and also it is not acceptable in a plural society like India. So in this line, it is said that when and if a uniform civil code is brought into effect, it will have to ensure a balance between protection of fundamental rights and religious principles of different communities. And before enacting any common personal law, it is necessary to take into confidence all the religion and the communities of India. This article on page number 7 is related to the continuing stalemate or the continuing political stalemate in case of Myanmar. And this political stalemate had started in case of Myanmar because of the military coup that happened 21 months back. So even after such a long period of time, there is no resolution to the political crisis that is happening in case of Myanmar. Now, Myanmar is a very important location and a very important partner of India in case of India's Act East policy because Myanmar acts as a gateway to Southeast Asian nations. Plus, India is also embarking upon various connectivity projects, and that is why it is important for us to understand the issues associated with India-Myanmar relations and why is Myanmar crucial to India's Act East policy and especially its policy towards the ASEAN countries and Southeast Asian countries. So let us look at all these aspects one by one. This editorial on page number 6 is related to Myanmar, and it is related to the internal politics of Myanmar. In this regard, you should know that Myanmar had witnessed a military coup in the last few years, and that has been a cause of concern for the international community, and that has also posed challenges for India's diplomacy. In this regard, the international community has been forcing India to take a stand on the military coup that has taken place in Myanmar and highlight the human rights abuses in case of Myanmar. However, Myanmar being one of the important neighboring countries of India in the northeastern part of India, India has tried to abstain from criticizing any internal political move of Myanmar in the view of importance that Myanmar has for India. So if you look at the map of Myanmar, it lies or borders with the northeastern states of India. And that is why Myanmar becomes very, very important for the security of the northeastern states of India. In this regard, if you look at the location of Myanmar, it acts as a bridge between the South Asia and the Southeast Asia. So these are the Southeast Asian countries including Thailand, Indonesia, etc. And Myanmar can act as a bridge between the South Asian countries, that is India, Pakistan, etc. and the Southeast Asian countries. Further, because the Myanmar borders the northeastern states, it can be a very important aspect for northeastern states' security because various insurgent groups that are responsible for insurgency in the northeastern states like Nagaland, etc. have been operating from the Myanmar's land territory. Also, China has been trying to increase its influence in the Myanmar, and that is why China is planning to work upon the China-Myanmar economic corridor so that it can have direct access to the Bay of Bengal or the Indian Ocean, and it can bypass its Malacca dilemma. And further, because of the landlocked situation of the northeastern states of India and a narrow passage that connects these northeastern states to mainland India, India has been trying to develop various infrastructure projects including India-Myanmar-Thailand Trilateral Highway and Kaladan Multimodal Project in order to improve the connectivity situation in the northeastern states of India so that India can have an access into the northeastern states through the Bay of Bengal, Myanmar into northeastern states. So let us look at all these aspects regarding India-Myanmar relations and why Myanmar is important to India. In this regard, if you look at India's policy towards Myanmar, we all are aware that military coup has taken place in Myanmar few years back. In this regard, the international community has been urging India to take a stand on the internal politics of Myanmar, that is the military coup, and talk about the democratization of Myanmar. However, India has been taking a policy of non-interference in the internal politics since 1990s because previously also the Myanmar was under the military regime. And India has always supported the democratization of the Myanmar driven from within the country and not the one which has been imposed by the outside countries. Now this is important because this has allowed India the scope to engage with military and also the political parties if they are in power. That is, whoever comes to power in Myanmar, this has allowed India to engage with any one of them in order to meet its own interests. Secondly, the position of India regarding the military coup has been engagement rather than criticizing the military coup that has taken place in case of Myanmar. And India has been focusing on engaging rather than criticizing as the most practical approach to finding a solution. Further, focus of India has been on balancing the influence of China in the Myanmar. And we all are aware that China has been trying to develop the China-Myanmar economic corridor so that it can have access to Indian Ocean region and bypass its Malacca dilemma. Now, this is also a cause of concern because of the growing India-China tensions in the recent time. In this regard, India has been trying to improve its relations with Myanmar by various diplomatic moves. For example, India has taken an important step towards establishing its embassy in the Naypyidaw, which is the new capital of Myanmar, where previously India had its embassy in the Yangon, which was the former capital. Further, we all are aware that Myanmar is important for border security and development, and both these countries have collaborated in terms of border security so that the insurgent groups that operate into the states of northeastern India do not operate from the land territory of Myanmar. Also, India and Myanmar have been focusing on strategic infrastructure development where India has proposed build-up of a petroleum refinery in China, especially in order to compete with the Chinese presence in Myanmar. Also, India has been focusing on various infrastructure projects like the Sitwe port, as you can see in this map, and also the Kaladan multimodal project, which will provide access to Mizoram from the Bay of Bengal via the Myanmar into Mizoram in the northeastern states of India. So that is why these are important. Plus, India has been focusing on developing the India-Myanmar-Thailand trilateral highway because Myanmar can act as a gateway to the Southeast Asian nations. So this brings us to what is the importance of Myanmar for India. So if you look at the importance of Myanmar for India, Myanmar is key in linking South Asia to Southeast Asia, which can be clearly seen from the map of Myanmar, which links South Asia to Southeast Asia. Also, Myanmar is important because it stands at the confluence of India's Neighborhood First policy and Act East policy. Also, connectivity projects to Myanmar will help India in overcoming its chicken neck dilemma or the Siliguri corridor, which is a narrow corridor that connects the northeastern states of India with the mainland territory of India. Also, Myanmar is crucial for security and development of the northeastern states. So these are few highlights of the importance of the Myanmar for India and how India has been pursuing its foreign policy towards Myanmar. With this, let's take up the next news article. This article on page number 12 is related to snow leopard conservation in Kashmir. In this line, the government is now considering using camera traps in order to highlight or understand how many snow leopards exist in the snow leopard landscape of India. In this regard, it can be a very important species for us from the prelims examination perspective in the environment, ecology and biodiversity section. So let us understand some important facts associated with snow leopard from our preliminary examination perspective. So regarding snow leopard, you should note that these are native to the mountain ranges of Central and South Asia. And you can see that it is found in countries like Afghanistan, Bhutan, China, India, Kazakhstan, Kyrgyzstan, Mongolia, Nepal, Pakistan, Tajikistan and Uzbekistan. Now presently their population varies from 4,000 to 8,500 and recently the snow leopard was sighted and reported from Thembang Community Conserved Area. And this lies outside the protected area of the Namdapha National Park and the Dibang Biosphere Reserve. Now all these aspects of the snow leopard have been covered in the prelims campus of environment and ecology. And this was mainly in news because of sighting of one snow leopard from the Thembang Community Conserved Area. Now, as far as its protection status is concerned, it is listed as vulnerable under the IUCN's Red List. As far as its conservation status in India is concerned, it is listed under the Schedule 1 of the Wildlife Protection Act 1972. Further, there are various global efforts that are being undertaken to conserve this snow leopard. First in this line is the Global Snow Leopard Ecosystem Protection Program. And this Global Snow Leopard Ecosystem Protection Program was launched in the year 2013 when 12 snow leopard range countries partnered and signed the Bishkek Declaration. And all these countries agreed to secure at least 20 snow leopard landscapes across their ranges by 2020. And this initiative was known as Secure 20 by 2020. So this is one of the important initiatives regarding the snow leopard globally. Now, as far as India's own snow leopard project is concerned, it was launched in the year 2009. And it was launched with a view to safeguard and conserve India's unique natural heritage of high altitude wildlife populations. Now, in this regard, what becomes important is the range of this snow leopard. So it is found in the erstwhile state of Jammu and Kashmir, Himachal Pradesh, Uttarakhand, Arunachal Pradesh and Sikkim. So these are a few important points related to the snow leopard and which can be important for us from the preliminary examination point of view. With this, let's take up the next article. This article on page number 5 is related to an important species of the bee which has been discovered in the Western Ghats. Now this discovery is important because it is after 200 years that a new species of bee has been discovered in India. And that is why it can be an important aspect for us from the preliminary examination perspective. That is, a new species of the bee which has been discovered in India has been discovered in which part? So it has been discovered in the Western Ghats and we should be aware of that. So let us look at some of the aspects of this new discovery. So a new species of endemic honeybee has been discovered in the Western Ghats and we should be aware of the location where this new bee has been discovered. It is basically termed as Indian black honeybee. Further, the scientific name that has been given to this newly discovered bee is Apis carinjodian, and it has been given the common name as the Indian black honeybee. Now it is very important discovery because it is after a gap of 200 years that a new species of honeybee has been spotted in the Western Ghats. So as far as its distribution is concerned, this Apis carinjodian ranges from the central Western Ghats and Nilgiris to the southern Western Ghats covering the states of Goa, Karnataka, Kerala and Tamil Nadu. So the distribution, the location, and this discovery and the name that has been given to this bee is important for us from prelims examination perspective.